the Supreme Court. The Supreme Court has commuted the death sentence of a convict. He's Mahendra Nath. He was convicted for 2 murders in 1997, but his death sentence has now been commuted to life. Now, the grounds are certainly interesting. The Supreme Court commuting the death penalty on grounds of delay in execution. And that certainly is going to give fresh hope to those people who want the same kind of leniency to be given to Devinder Pal Singh Bhullar. He's a Khalistani terrorist who's been convicted for the Delhi blast case, and his supporters have been demanding that his death sentence be also commuted to life on the same grounds, delay in execution. The Supreme Court had earlier declined to commute Bhullar's death sentence on the grounds of delay. Human rights activists had been citing Mahendra Nath's case to seek a review of Bhullar's mercy plea. Mahendra Nath Das's mercy plea was reviewed twice but was rejected by the President. Let's get more from Ashok Bagaria reporting from the Supreme Court. Ashok, are there very clear parallels between these two cases?
Well, as far as Devinder Pal Singh Bhullar's case is concerned and M.N. Das's case is concerned, they stand on 2 different footings. As far as Bhullar was concerned, he was convicted under TADA, whereas Das was convicted under Section 302 of the Indian Penal Code. Now, in Bhullar's case, we have seen earlier that the Supreme Court, while disposing his petition, had drawn a distinction and said that in cases of terror, a death penalty cannot be commuted to life sentence, whatever may be the delay. But in M.N. Das's case, the Supreme Court has taken this distinction a step forward and made sure that in cases of personal enmity or revenge, actions or murders or actions which take place outside or are motivated by personal enmity, in that instances, death penalty can be commuted to life sentence if there is an inordinate delay on the part of the President in deciding the mercy plea. In this particular case of M.N. Das, there was a delay of 12 years by the President's House in deciding. The mercy plea was first put forward in 1999 and it was only decided by the President of India in 2011. So on that ground, Das had approached the Supreme Court saying that there has been a unsubstantiated delay, and today the court has upheld that argument.
Interesting. So, Ashok, you're suggesting that the Supreme Court making a distinction because Devinder Pal Singh is a terrorist, and the Supreme Court suggesting that terrorists should not be given any benefit of delay in execution, and therefore should not their death sentence should continue. However, Devinder Pal Singh has another condition. It's a mental health condition, and his supporters certainly believe on those grounds he should have got leniency.
Well, that was an argument which was put in the Supreme Court, and the Supreme Court dealt with that argument. In fact, the Supreme Court had called for the medical records of Bhullar, and the court in its judgment, or rather in its opinion, had come to the conclusion that his mental condition was not of such a grave nature that it could not be cured, or he could not be, or that it made a ground for reducing his death penalty to a life sentence. So that part of the argument has been dealt with the Supreme Court, and they have come to a conclusion that as far as Bhullar is concerned, his the mental disorder ground taken by him did not weigh actually well with the Supreme Court.
So are we expecting Bhullar's camp to move perhaps a review petition or a curative petition?
Well, legally, I don't think that that kind of a leeway is available to them. But as far as extra legal mechanisms are concerned, there will be a political uproar, and there will be demonstrations outside, where this whole thing will be taken up. The M.N. Das judgment will be taken up. Parallels will be drawn where they will say that there was an equal amount of delay in Das case as well as Bhullar's case.